This video is for educational purposes only and does not constitute legal advice. A small 200-employee US-based company, with no physical presence in Europe, came to the attention of Norwegian regulators in 2021 and ended up being assessed a €6.5 million fine. The company operates a website and mobile app that connects people for dating or more casual relationships with millions of worldwide users. The company shared personal data with advertising partners, including advertising ID, IP address, device information, age, gender, and location. They claimed consent as the legal basis for sharing this data under Article 6, Paragraph 1a of the GDPR, stating their consent mechanism was compliant at the time. The company maintained that their consent mechanism allowed for a set of processing activities as long as data subjects received specific information in advance. They argued that the consent did not need to be separate for different processing operations, referencing French regulator guidelines on cookies and a decision by the French Council of State to support their case. The company also argued around other supervisory authorities allowing grace periods. The Norwegian regulator made clear that guidance from supervisory authorities outside of Norway is not binding on other supervisory authorities. The other supervisory authorities are enforcing their own consent requirements. It should also be noted that neither the GDPR nor Norwegian law allows for grace periods, as the controller is responsible for, and must be able to demonstrate, compliance with the GDPR at any time, according to Article 5, Paragraph 2 and Article 24. Norwegian regulators also disagreed with the company's interpretation of consent, stating that consent must be freely given, specific, informed, and unambiguous. The regulators started by stating that consent was not freely given. They found that the company's consent was conditional upon the acceptance of a long privacy policy that bundled various processing purposes, contrary to the requirement of granular consent. The process to withdraw consent appeared tangibly more burdensome than providing consent. The company did not allow separate consents to different personal data processing operations despite it being appropriate. Access to services in the free version of the app was made conditional on consenting to sharing personal data with advertising partners despite this not being necessary for the performance of the service, and data subjects could not refuse or withdraw consent without detriment. For these reasons, consents collected for the disclosure of personal data to advertising partners were not freely given. The regulators next said that the consent was not specific or informed. Consent mechanisms were not specific to the sharing of personal data for advertising purposes and was instead inferred from acceptance of the privacy policy. The company's long privacy policy and its bundling with other consents impeded the data subject's ability to understand the consequences of consent, making it not informed. The regulators also believed that consent was not unambiguous. The consent mechanism did not clearly distinguish consent for advertising from other data processing activities, making it ambiguous. The regulator also mentioned that opting out is not equivalent to giving consent under GDPR. The regulator argued that the company shared data concerning users' sexual orientation, which is a special category of personal data under GDPR, requiring additional protection. The company countered that the mere use of the app or keywords did not directly reveal sexual orientation. However, the regulator determined that being a user did concern a person's sexual orientation, and such information was not manifestly made public by the user, thus breaching GDPR Article 9, Paragraph 1. The regulator also cited a lack of transparency and understanding on the part of the company. The ad tech ecosystem's complexity and the company's failure to ensure transparency and understanding of the data processing activities for users compounded the gravity of the infringements. The regulator concluded that the company, through its board members or executives, acted negligently, and possibly intentionally, in violating the GDPR. A €6.5 million fine was assessed. Please visit our website at governorstow.com for more information or to sign up to our weekly newsletter or, if you prefer, follow Governor Stow on LinkedIn, YouTube, X, and Instagram.